Hello everyone, and welcome to the Dice Commando YouTube channel. I'm Andrew, with you here as always. This is the Commando Cast, a video cast about all things Star Wars Destiny. This video and others like this one are possible thanks to viewers like you. Please show your support with a like and subscribe, and be sure to hit the bell notification icon so you don't miss any new videos. If you want to get involved with the channel, consider becoming a channel member. There are many benefits to channel membership, including access to our Discord, exclusive deck tech and strategy videos, and the opportunity to help create channel content. I want to sincerely thank all our channel members, as I truly couldn't do this without your support. You guys rock. Go Commando.
Earlier this month, in what was perhaps the tabletop gaming baller move of the decade, an individual by the name of Robert Hovden successfully fired for the first ever copyright on a Magic the Gathering deck. What? You can't do that, right? Wait, can you? Certainly, this copyright won't be upheld, right? Or will it? What does it mean for us as gamers? This could change everything. Whoa, let's pump the brakes, right? So first, yes, one can in fact do this, and yes, it likely will be upheld. So does that mean we should all go out and develop a computer program to generate every possible combination of cards in our games, thus locking our opponents out of playing against us forever? No. Realistically, the implications of this whole thing are ultimately quite minimal. That said, it's A, quite hilarious, and B, quite interesting. So today we're talking about what happened, how it can even happen in the first place, and what that means to us, if actually anything at all. Hello everyone, and welcome to Dice Commando, where we cover games and gaming-related craziness of all types. And when I learned about today's topic, I found it extremely fascinating and certainly worth discussing. So as part of today's video, we're going to be talking about IP, or intellectual property, laws and practices. However, it is important to note that I am not an IP attorney, nor do I play one on the YouTubes. However, in addition to the very limited research that I've done to prepare for today's video, I'm certainly no stranger to the world of IP. I hold an inventor patent at the U.S. Patent Office. Through my numerous technical publications, I have extensive copyrights, and I have a limited understanding of copyright protection, fair use laws, and such from my years of doing YouTube videos. So while I must be crystal clear here that I in no way should anything I'm saying here be construed as legal advice, I do feel quite comfortable talking knowledgeably about the subject from a news and an analysis point of view. Also, it's important to note that Hovden has a reputation of being a bit of a kicker when it comes to using corner cases to highlight holes or loopholes within U.S. copyright law. Essentially, he has a history of being the internet troll equivalent to the U.S. Copyright Office. So, all right, he's succeeded, haha, and they fixed the problem, right? Not necessarily. But then, is it even from a technical standpoint actually a problem at all? And as many articles out there are claiming, does it have massive potential impacts to the gaming community? So the first thing to note is that most people relate IP property discussions just in their head to the concept actually of what a patent actually is. And in reality, there are several different types of IP protections. Many individuals' understandings have actually been formed via taking pieces from all of these and drawing their own picture of what reality is, which is not too different than the news these days, right? So let's start out by going through what the various forms of IP protection actually are, what they mean exactly, and then put them into context of today's issue. So a patent protects the rights of an inventor or inventors for a limited duration of time, typically like 20 years. Basically, it gives them exclusive property rights granted by the patent for an invention. Patents take the form of design patents, which protects like an actual original creation, or process method patents, which protect a business process or manufacturing method, something like that. So in short, a patent ultimately entitles you or the inventor to exclude others from making, using, or selling your invention, or using your particular patented method or process of doing so. Now, it's important to note that you can't patent a natural thing that already exists. We kind of joke about it in my industry all the time, saying you can't patent science, but you can patent how you achieve science. In my case, I have what's called a process patent. I can't patent a silicon nanoparticle. It's a thing that exists. But my patent does allow me to protect the method I developed in which we produce those silicon nanoparticles. Right. So next we have trademarks. Now, trademarks are what we see quite frequently, right? Symbols, words, slogans, logos, colors, whatever it may be that identifies a particular product, service, or company and distinguishes it from those that are made or provided by similar stuff in the field. And trademarks have to deal specifically with names and logos. Classic example of this is something like a Kleenex, right? Kleenex can't, patent the concept of wiping your nose with a paper-based cloth. But they can trademark the name Kleenex, and potentially they can patent the way in which they make it. But they can't stop someone else from making a paper-based product with which to wipe your nose. But no one else could be able to call that product that they were to make Kleenex. The same is applicable to logos like the one on my hat, designs, and so on. It's also important to note that in many of these cases, there's an allowance of crossover to a certain degree in certain industry. And actually, while we're on the topic, beer names are actually a good example of that. You'll have a lot of, funny beer names out there that play on words or talk about other events or other companies or what it may be. And, while it's certainly possible that the owner of that trademark could cease and desist them, and in most cases, they would just not want to have the legal battle and it would end there. In most cases, there's an allowance made because it's not actually hurting anything, right, from a legal standpoint. And finally, and kind of the more relevant, so the other two do matter, but finally the more relevant because it's actually a copyright. What copyrights do is it protects the right of authors or creators in their original creative works. This includes artistic creations like novels, paintings, writings, of course, but also stuff like software code, architectural drawings, even like reports. Marketing reports even, right? And the author, the creator of a copyrighted work has the exclusive right to basically reproduce that, to license it, to publish it, to perform it, as it may be, and to allow others to do so, but they still hold the right of reproduction or reproducing it. Okay, so copyrights are an interesting thing, though, right? And hence, I think, of course, why the individual in question has kind of made a hobby of really trolling them. So one of the best and relevant to this channel examples of what isn't protected is achieved by looking at Magic itself, right, as a game. So you can't prohibit trading card games. Otherwise, we wouldn't have an industry, right? It would just be Magic and nothing. You can't even own a game mechanic, such as the action of turning a card sideways to mark that the card has been used or activated. You can, however, prevent calling said mechanic a certain thing, as that would thus infringe upon using the same rules of your game. And that's why non-Wizards games through the years don't use the word tap, despite basically functionally being tapping, right? Now, another interesting thing about copyrights is that there are limited protections provided simply by creating the work itself. Nothing needs to be formally approved through the Copyright Office, right? Like works of art you don't actually submit like this is my painting to the Copyright Office. My videos, for example, are protected through limited copyright protection. Someone couldn't just download my video and repost it without my legal consent. Likenesses versus names is also relevant, and Star Wars, as we talk about all the time here, is another great example of the limits of copyright law. So Disney certainly owns something like Aayla Secura as a character, but they don't necessarily own her likeness. And this is why third-party individuals are able to still, Star-Lord General Miniature that's basically Aayla but isn't called that. Or similarly for Wizard Warrior Gindu instead of Mace Windu. This is why terrain companies sell Desert Planet instead of Tatooine, or Forest Moon versus Endor, right? Then finally, last in the chain, we have fair use laws, which are something that on this channel we actually run up against a lot. In essence, using the previous examples, how am I even able to say the name Aayla Secura or Mace Windu without having the mouse come down on me with like a ton of bricks? How am I able to show actual images of Flesh and Blood cards or art owned by Legend Story Studios on my channel or as a thumbnail without actually getting in trouble? And these fall into what's known as fair use, which at like a 10,000 foot level allows for use of items such as the ones I just mentioned in actions as a review or a survey. Now, if I were to use some of LSS's art on a product by which I was selling or somehow infringed upon their ability to sell theirs, that would arguably be crossing a line. And of course, none of this stops them from actually sending me a cease and desist, which of course means I would immediately tuck my tail between my legs and run and just take it down because I wouldn't want to have the legal battle. But at a general level, using something in a review or a survey is considered fair use as long as it's basically not infringing their ability to do what they want to do. All right, so with all of that said and understood, I want to bring us back to the direct relevance to this case. So as a creator, you can copyright what are informally known as collected works or collections. You couldn't copyright a library, for example, but you could copyright the curated list of work housed within that library. And this is where this particular case falls into. He isn't copyrighting the cards or use of the deck, but he's copyrighting the collection of those specific cards into a collected work. So one could create, for example, a summer reading list of a bunch of other people's books and would still retain the exclusive rights to that collected work, the summer reading list, despite having no rights to any of the books on that list. And that's very similar to the deck list in this case. Now, the next part of this discussion pops up with respect to preventing others from using the deck in competitive play, which is, I think, fair to say, most people's concerns about how it's going to destroy the industry. And I want to take a minute and explore this situation in one that's far less emotional to our viewer base. So a fantastic analogy to our situation here is that of like a cookbook or a recipe. One can't copyright spaghetti sauce and thus prevent all others ever from making and selling spaghetti sauce. One could, however, copyright their specific sauce recipe by, say, listing the ingredients and the method by which they made it, right? Even so, you couldn't prevent someone from using your copyrighted recipe, making it and selling it. You'd have to patent it to do that, right? That would be a patent as a direct invention. And even so, in the case that we're specifically talking about, likely would not be approved by the patent office because it's not really unique, right? All the copyright does is prevent someone else from publishing your recipe as their own, such as in their own book. And what's more is that someone could even take that and review it on their blog or video, writing the recipe down and sharing it, because this all falls under fair use laws. No wonder grandma won't let out the secret recipe. You know what I'm saying? Okay, so now, using that example and putting it in perspective, what this means is that Angels and Demons, the copyrighted Magic deck, does not prevent anyone from playing it. If I were to copyright tomorrow my own Demure Rogues deck, other players would absolutely be able to take it to a tournament tomorrow. Those players would then even be able to share it as the deck they played in an article or on a YouTube video. They simply would not be able to publish it and distribute it as their own individual idea. So there you have it. What is the actual true impact of the gaming community as a whole following the first copyright of a Magic the Gathering deck? Virtually nothing. Legally relevant and interesting, for sure, in some corner cases. But for the vast majority of us players and collectors, it really means nothing. So before we close out today, I again feel it very necessary to remind you that I'm not an IP attorney, and I'm here merely sharing my opinion based on the current information available to me based on my current understanding of the situation. And that this video is provided for entertainment purposes only. Just like in any other financial or professional situation, you are advised to seek professional advice prior to making any relevant decisions or actions. So hopefully you enjoyed hanging out tonight. I thought this was a really fun and interesting topic. And had seen, kind of as per normal, especially in the world right now, a lot of unnecessary concern and a lot of inaccurate information being passed around out there. So while as stated, my understanding of a very, very complex issue is certainly fundamental, it does highlight that we're not all at risk of being copyrighted out of playing our favorite games. So thank you very much for joining me tonight. Keep making those deck lists, and go Commando.